Hi, this is Rich Sierra, President of the Florida Small Business Legal Center. Today we're going to talk about not hiring a lawyer to save money. Talking about Business SOS. This is the book that is in Amazon, Barnes & Noble, and ask for it in local bookstores. I'm going to talk about mistake number one. First of all, before we start, I'd like to give a big shout out to my son Jonathan. Today's his birthday. Very, very proud of you and love you. And also I have a special guest here with me in the audience. I have my beautiful wife Sharon. Baby, how are you? She's camera shy, so she's not in the camera today. But it's great to have a live audience watching the show. Very excited. So let's get started. One of the things that what motivated me to write the book is that, and I'm going to talk about some of the mistakes that even I encountered this week. I talk approximately about 10 to 15 prospective clients every week that want to consider me to hire for its legal services. And I find a common theme that takes place when I speak with them. So I thought that today will be a great day to talk about mistake number one in the book, which is not hiring a lawyer to save money. And many times, and I'll just give you an example. This week I talked to a client that, he was sued. He lives in Texas, and he was sued in Florida for something that happened in Texas. For whatever reason, he was sued in Broward County because one of the defendants had a connection to Broward County, Florida, Fort Lauderdale. So when I looked at the lawsuit, I said, I'm not sure why you're being sued in Florida because you live in Texas. One time he lived in Palm Beach, but no connections to Broward. So he really had no what is called minimum contacts with that venue, with that forum state. And that's, I'm not going to go into a legal analysis of jurisdiction. But the bottom line is that he should have never been sued in Florida. So as we were going to my strategy, my game plan, and my recommendation, which was to, listen, let's go ahead and get this dismissed. For lack of subject matter jurisdiction. You don't have to be sued here. They're certainly welcome to sue you in Texas, where you live, but they don't have to sue you here. So we're talking. We spent a good half an hour discussing the matter and why the other party was involved. And as we were, say, when I hire you to represent me, that's great. And then he said, listen, I forgot to tell you something. And in my experience, nothing good comes after somebody tells you, I forgot to tell you something. So I said, okay, what happened? Yeah, I called the courthouse when I received this letter, and I talked to somebody there. I'm not sure if it was the clerk or one of the clerks. They suggested that I, write a letter explaining my position and send it to the court. And he said, also, I talked to a friend of mine that works for a law firm here, and she works as a paralegal, and she suggested I do the same thing. And so I had a big pause, and I said, that's a very, very big mistake. You should have never done that. I said, specifically what this letter contains. What did you write in this letter? And he said, yeah, I just kind of explained my position. I explained the other party was at fault. It had nothing to do with it. That the party people knew that I live in Texas. I should have never been sued there. And it was a kind of a long letter. So I said, do me a favor, send it to me. And also don't do that again. If you by chance get sued, do not defend a lawsuit by yourself. Do not send a letter to the court. Don't do anything. You have to make sure that you retain counsel first. So I said, it is not a fatal mistake because, at least in Florida, you can allege lack of subject matter jurisdiction at any time. But it makes it more challenging if you respond to a lawsuit and you're saying, I should not be sued here, but you respond to it, that's going to be considered an answer. So the other party may say, you know what, I understand what they're saying, but in reality, they're already in the lawsuit because they already answered the lawsuit. So it is So it kind of gives more ammunition to the other side, to the plaintiff in this case, to keep you there. So the first thing you got to do if you get sued, you know, am I being sued in the right place? And that's the reason you want to have an attorney review that lawsuit before you do anything. Fortunately, because of a technical issue with the court, when it was sent to the court, it was not signed. So the court rejected that quote-unquote filing because it was not signed by my client. And by rejecting the filing, it was as if it's never been filed in the first place. So that was a happy accident, so to speak, but it was a close call. So mistake number one of the mistakes there are several mistakes that I mentioned in my book, Business SOS, is, you know, representing yourself or responding to a lawsuit by yourself, especially if a lawsuit is filed by an attorney. If a lawsuit is in small claims court, there's a neighbor suing another neighbor, and you can get counsel, but in small claims court, the rules are a little bit different. There's more flexibility, so you can go ahead and not necessarily have to, need an attorney for that. But anything beyond that, you have to have an attorney review it. So another situation that I had this last week was another client that, signed some documents. They hire an appraiser to do some things, appraise the house, and there was some type of insurance claim. And there were some documents signed. The client did not hear from this individual for nearly 3 years, but ultimately, the insurance company provided some type of settlement, some type of the property damage. So I was explaining this, looking at this lawsuit, and what happened is the appraiser ended up suing my client because services rendered and he didn't pay. When I asked my client what happened here, so listen, I signed this contract. It's not his primary language, native language. His native language is Spanish. So I said, do you understand the contract when you signed the contract? And I said, he told me, kind of understood it. I was not very sure. And I'm like, well, do not sign a contract if you do not understand it. Do you have a friend or a neighbor that could help you? No, I live by myself. I didn't have anybody to help me at the time. So we're still dealing with that, but this could have been avoided to the extent that that contract could have been interpreted by someone who, and there's plenty of people that speak Spanish, that can actually interpret the contract properly in the native language. It could be Italian, it could be Spanish, it could be Swedish, it doesn't matter. The point is that as people come in to Florida and to the country and to investor visas, sometimes they want to buy businesses to invest, and there are a lot of complex legal documents that are presented that are signed, like franchise agreements, lease agreements, buy-sell agreements. And what happened is that the attorney may speak the language, but however, the client would not. It is important that if a client is going to sign a document, the client needs to understand that document. And I've said this before, as they say, what do you think, should I sign it? And I get that question asked repeatedly, and I'm like, well, that's up to you. I need to make sure that you understand each and every aspect of this contract. And if you do not understand it, tell me, and I'm happy to clarify it for you. But ultimately, you will be living with this contract, not me. So it doesn't matter whether I think you should sign it for the purposes of whether it's a legal contract. The question is whether this deal that you're signing is good for you. Because as I said in prior episodes, it's not whether the contract is legal, it's whether the contract is good for you, whether it's to your benefit, whether you understand it. And if you do not understand the provisions, do not sign it. Take a pause, take a step back. You can now, it's so easy with Google translators or with the various different software and applications that you can actually take a document, cut and paste it into a different application, and then you have the document, for the most part, interpreted, translated into your native language. So at the very least, get the proper assistance, get the proper help. There's plenty of people available. It's simply a matter of having the motivation and the initiative to do so. But that goes also with contracts in general. The contracts are drafted for the most part, especially in commercial transactions, by attorneys. So if you're a business owner, you're about to buy a business, and in fact, I had another consultation this week of a client that wanted to sell her business, was a franchise, and they want a quote-unquote a simple contract. Contracts are not that simple. Contracts are, contract law is very complex, very technical. The simplicity comes into the language and how clear the terms are. So I asked about, tell me a little bit more about a transaction. It's going to be a cash deal. There's some due diligence. We want to close sometime at the end of the year, December. And today is June, June 9th to be exact. So I'm like, well, you're talking about a 6-month period, and a lot of things can happen in 6 months because you need to run the business the way it is today for the next 6 months and guarantee, for the most part, assure the buyer that there's not going to be any material changes in that business all the way through the end of the year. So you can have a letter of intent, you can have an asset purchase agreement, and they also would like to continue having due diligence all the way through the maybe 15 days before the closing to make sure that nothing is changed. So we left it at that, and then I'll explain, what I could do, and, we'll talk sometime in the future. But the point is this, you have to have clarity. When you're going to basically buy or sell a business, get an attorney. It is complex, it is difficult, and it should not be done. It's not something you download from the web to save a few $100s. Again, that is my opinion. Another issue that comes up very often is that people have, breach of contract cases. And again, as I mentioned before, a lot of business litigation stems, for the most part, from a contract dispute. It could be an oral contract, it could be a written contract, but it's usually a contract dispute. It's somebody that, either they agreed to do something and then somebody had the perception that somebody breached the contract. So it's usually a disagreement that involves some type of money or obligation. So they go on the web and they look for answers, and there's a lot of good information out there. A lot of attorneys write blogs and they give you a lot of good information. However, it is a mistake to assume that the information that you find on the web is going to be applicable to your situation. It is not. There's some concepts that you can draw from reading a blog, but your situation is unique. In a breach of contract claim, you got to find out, for example, what the document states. Is it clear? What did the parties agree to? What was the obligation? Who breached the contract first? Was it a material breach or was it immaterial? Just to give you a few examples. So your situation is very important. And I have a situation, I'll give you another example of somebody that was they bought a business, and then for whatever reason, the financials that they received from the seller before the closing, they perceived that the financials were, let's say, fraudulent, or they were not accurate. So as part of that buy-sell agreement, there was a promissory note, say of $100,000 they were paying on a monthly basis. So they reached out to the seller and said, listen, the sales that you projected, that you told me you were having for the last 3 years when I bought the business, they're not the same. So we want to go ahead and renegotiate this. The seller disagreed. They didn't agree to those terms, but the seller, as a concession, as a way to kind of smooth things out and not have to deal with the situation, agreed to reduce the note by $25,000. So they did another amendment to the agreement, and then went ahead and reduced the note to $75,000. But they also signed something called a release of liability, basically saying that any claims that could have been discovered up to the date of the signing of that release, they're barred, meaning that you cannot bring them up. I was not involved in that transaction. This is basically something that came after the fact with me. So they started paying the $75,000 monthly and all that. Then he finds out that prior to the closing, there was a big supplier that my client was relying upon, that the contract actually expired and he did not have that distribution of that supply, after, in a 30-day period. This is an online company that they were basically selling products, but they were relying on this big supplier. So they came to me and I said, what should we do? So I looked at the facts and I said, you have a problem. Sometimes I don't give good news, and sorry about that, but that's the way it works. So, and I said, listen, this is what you have here, okay? When you went ahead and agreed to the $75,000 reduction of the promissory note, you also, not only you signed a brand new agreement, but you also signed a release of liability, meaning that you agreed that you will not bring anything else up again for this concession before anything that you have discovered, could have discovered before you signed that agreement, you cannot bring it up again. There are exceptions to that, but it makes it more difficult when you have a release of liability that is signed in a renegotiated contract, especially if something that you knew you have known, and you also had access to that distributor and could have contacted the distributor. Doesn't mean that you are completely out of luck, because you can claim what is called negligent misrepresentation. You can claim fraud and inducement, but it makes it more difficult to pursue a breach of contract claim when there's a release of liability involved. Excuse me a second. So, excuse me. So this is why it's important to have an attorney review the contract and have an attorney explain to you the consequences of renegotiating a contract after the fact and agreeing to certain terms. And I get that repeatedly in my office. Another common mistake that I see, and people well intended, and it's mistake number 3 in my, with the mistake number 1 of the book, is consulting with a friend, family member, neighbor, relative who is in a legal professional. And those things can end up badly. And sometimes they do. people well intended. People have great, especially friends and neighbors and family members, they have great intentions to assist. But there's certain things that should be left to professionals. I would say medicine is one of them, and obviously law is another one. Number one, the conversation with attorneys is confidential and privileged, and nobody can go ahead and ask you can ask a lawyer to testify about that conversation, and also nobody can ask you to talk about the conversation you had with the attorney. There's some exceptions, but we don't have to go into that right now. Number two is the expertise. When you have a friend or relative say, yeah, let me take a look at that, go ahead and write a letter, like happened to my client, that he had a friend say, listen, write a letter to the court, it is fine. And what happens is that you can end up making matters worse. And I've had situations that even with some of my clients that said, I present a recommendation. They said, I want to talk with my brother who, and I'm like, well, is he an attorney? When somebody's giving you legal advice is very technical, very precise, and it's based on years of experience and knowledge and also understanding the law. So although you can consult with your spouse or significant other and regarding a decision you're going to make, that is an important decision. But talking about a legal option, a legal advice should be left to an attorney. And another issue that I run into, which I believe is also a mistake, is that shopping for an attorney based on price. And I understand that everybody wants to get a good deal, and that is fine. Nothing wrong with that. But the issue that I have is that when you're looking, price is the determining factor to seeking an attorney. It becomes, your legal issue is very unique and very important. And expertise costs. Expertise costs money. Excellence costs money. And my take on this is that if you pay well at the beginning for the services that you're going to be receiving, specifically an attorney, you're going to be better off than that price being the determining factor. And that, again, that's my opinion. But price should not be a determining factor. Obviously, if there's certain budget limitations that you may have, that's fair. But all things being equal, you want to make sure you get the person that is qualified to help you with your legal problem, has its experience to help you with it, has handled that type of situation before, and you feel comfortable with that attorney to discuss your legal matter and have a level of trust and confidence and comfort that attorney is going to help you get through whatever legal problem you're facing at the time as fast as efficiently as possible. And there's open communication between you and your attorney. Those are the key things that I believe make a very productive attorney-client relationship. Another situation a question that I ask my clients is that, there are a number of options here. And especially trying to sue someone, listen, I'm owed $25,000 and then I want to basically recover that money. I said, well, there are a number of options here. Okay, you can do nothing and lose the money. It's not a pleasant option, but it's an option indeed. You can, go ahead and do initial, what we call a pre-suit demand letter, to see if we can try to resolve the matter without having the need to pursue litigation. That is another option. That is kind of what I call the interim step or an off-ramp before a litigation begins. Third, you can go into file the lawsuit and begin the litigation process, which is significantly expensive and in some cases could cost more than the claim that you're seeking, in this case, $25,000. And again, it is a choice. And sometimes there are no good choices here when you're trying to pursue a litigation. And the same thing happens when you're being sued. Sometimes the claims are so large that you said, there's no way, it's going to cost me way too much money. And the options are, you can go ahead and either agree to a judgment and perhaps seek bankruptcy. You can try to negotiate a payment plan. You can go ahead and defend and then negotiate. So an attorney can give you those options, and they're all valid options. What is important is the creativity that is applied to problem solving, utilizing the legal process. And that's what is different, and that's something you cannot find on the web. The web can give you some answers, it can give you some cases, but how it is applied to your situation, only an attorney can do that for you who has had the experience and the know-how on how to handle it and the creativity to apply the legal process to solve your problems. Just to make one point, that what I'm sharing with you today in episode 3, actually it's episode 3 or 4, does not apply, is not necessarily construed as legal advice. It is concepts that I share with you, but for legal advice, you need to speak with an attorney. But I'm basically sharing with you some concepts that may apply, may not, but that's not necessarily legal advice for you. I want to share with you, before I close, some questions that I ask my clients in an initial consultation. And I think that these are points that I think might be helpful to you as you have your first meeting with your attorney, what information to bring. And I think that if I share, you get a point, any point from today is that when you speak with an attorney, bring the information, bring the good, the bad, and the ugly. We can handle it. Do not withhold back information from your attorney thinking that might be embarrassing, thinking that, it might not be important. Just tell us. Just go ahead and tell the information. We're here to help. We want to know. I'd rather have bad news given to me right at the very beginning of the case, because then I can figure out how to address that, as opposed to telling me much later, I forgot to tell you something, and I'm already 6 months in. Because then to try to reverse that or try to fix that is more difficult. We also have a situation that when you withhold information from an attorney, the other side most likely knows that information. I repeat. When you withhold information from an attorney, the other side most likely knows that information, and it's going to come out. And, I'll give you a quick example. I had a client a few years ago that was alleging that he didn't get paid the right amount pursuant to a contract. It was a software developer. And, I went ahead and I sent this long demand letter, and then saying this is the money that is owed, this is the money that should be paid to this client. And then I end up getting a letter back, say, well, not only we paid him, but he has a lot of materials and some computer equipment that he has not returned. I did not know that. So, and there's a letter as well to that effect. So that correspondence would have been important to me right at the beginning, so I would have strategized it a lot better. And there was another example that this deal with an alarm company a few years ago, that a client basically closed his alarm company, and then one of the employees decided to go on his own and take some of those clients. And the way information was given to me was that, he didn't really close it. He was basically going through a transition, and he wanted to move to a different company. So, and he said he was not aware of, that his technician was taking these clients. So again, I sent this demand letter to the opposing side, claiming that they're interfering with our business relationship, they're stealing clients, et cetera, et cetera. Then I came to find out the opposing counsel sent me an email, which my client sent to all his clients, telling him, hey, just to let you know, I'm making a change. I'm closing the company down. I did not know that. So, needless to say, it didn't go well. Because would have I known that information beforehand, it would have been a different approach, or perhaps not even send the letter in the first place. So, by being forthcoming with your attorney, even with bad news, is fine. We can deal with it. We already know that you're coming to our office. You're having a consultation with us. We already know that something went wrong along the way. It could have been because something that you didn't do, or something that perhaps the other side didn't do. We already know that. So it's fine. You just tell us everything, and we can go ahead and prepare a strategy for that. So very quickly, this is from Business SOS, 8 common legal mistakes business owners make and how to avoid them. So this is chapter 1, and I'm going to read a little bit from page 16. And some of the questions that I ask my clients when they come to for a consultation: what are the circumstances that led you to schedule the consultation? Why are you calling me? And the reason I ask that question is because usually there's a threshold of stress that goes along with somebody making a phone call. Understand that calling an attorney can be stressful. Just the very thought of calling an attorney can be stressful. So we don't want to make that stressful. It shouldn't be. So I want to find out what led you to call me. And if you spoke to another attorney, what options have they discussed so far? Let's not reinvent the wheel. Let's find out whether any of those options work. For whatever reason, they didn't hire that attorney. So we want to find out what led them to, what options are discussed. What are your goals and expectations? What do you want to see happen? How do you want this problem to end? And we'll talk about that, because what we want to find out is basically whether the expectations that you have are realistic and whether they're attainable. And we want to talk about that, have that conversation. To ask about the fees and costs, about the services, as well as the billing process. You should know how much you're going to pay for the services, what is it included within the legal services, and how often you will be billed. You should know that, and that should be part of the retainer agreement. How long it will take the legal matter to resolve? And the answer is always it depends, because obviously there are certain things we can and cannot control. We can control, we send information out when we send a demand, but we cannot control how the other side is going to respond. But you can have benchmarks and milestones in different stages that can be accomplished. What are the attorney's concerns about the case? In essence, in my case, I will basically, what is not looking good for you in your case? Because every case has pros and cons. I said, this doesn't look good for us. And we'll talk about that. I'd rather get that out of the way at the beginning as opposed to not handling it. So we'll talk about that. What are the possibility for an early mediation to discuss settlement? As I mentioned before in a prior episode, mediation is something that I'm a very big proponent of. And early settlement is always good than a long litigation. How often will you receive updates on the case? Whether it's a weekly update, whether it's a weekly phone call, whether a weekly meeting. How often do you communicate and what method? By phone, email, text? The best and worst case scenarios. That's important to talk about. Your best day in court will look this way. Your worst day in court will look this way. The best way to solve this issue is going to be this particular way. The worst way, this is going to happen. So talk about the best and worst case scenarios. And whether or not the attorney has had the experience handling similar cases in the past. Experience does count. And it is important that your situation, unless it's extremely unique, has been handled before by an attorney. It is important to do that. That way, that experience gives you the insight and the creativity to be able to come up with creative solutions and how to solve the problem and get you out of it as soon as possible. I know I went through different topics here in this episode. I hope you enjoyed this chapter. This is Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. So I've made this offer to you, and I want to do it at this as well. I want you to be part of the show. So if you send me a legal question, and I'll select your question and talk about it, I'll send you an autographed copy of my book. I will not mention your name. I'll make a different name, but I'll definitely talk about it and go into some information. And I'll send you a copy of my book as well. I'll sign it. So how can you reach me? A number of ways. You can send me an email at rich@richsierra.com. If you're interested in learning more about the services that we offer through our law firm, go to floridasmallbusinesslegalcenter.com. You can find us on Facebook at FSB Legal. We have a YouTube channel. This is a podcast, but we also have a video if you're interested in watching the video of the podcast as well. It's youtube.com/@Richard Sierra. We're on Instagram at FSB Legal. You can always call us at 866-842-5202. Also remember that Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, is available on Amazon, Barnes & Noble. You can ask for it at your local bookstores. If you like the podcast, I'll ask you to please give us a 5-star review. If you'd like to write something about it, please do. And subscribe, follow us, so you get the update when it comes out. And also, the podcast also recommends this podcast to other business owners that can benefit from the information. Until next week, this is Rich Sierra with the Florida Small Business Legal Center, and I'll see you next week.